Hello, everyone. Welcome back to the LAOT podcast. I'm Arnav Mathur, and today we are going to discuss a constitutional review currently underway in the Supreme Court. Now, this review is not about a single statute, this is not about a single temple, this is not even about a single religion. This is about how the Indian Constitution understands religion at a fundamental level. This is the Sabarimala review petition. Here's what has happened so far. 8 years ago, in September of 2018, a five-judge constitutional bench held that the centuries old practice of barring the entry of women between the ages of 10 and 50 into the Sabarimala temple in Kerala was unconstitutional. The decision, on one hand, was invoked as a triumph for gender equality, but on the other hand, it was condemned as an assault on religious autonomy, and it was immediately challenged on review, which led to a reference in 2019, where a five-judge bench referred a cluster of questions to a nine-judge bench. Now, in April of 2026, 8 years after the original decision, the nine-judge bench, led by Chief Justice Surya Kant, has finally convened to answer these questions. One interesting point is that the 2019 reference order clubbed several petitions alongside Sabrimala. These include challenges to the exclusion of women from certain mosques, the denial of entry to Parsi women who had married outside their faith into the temples and towers of silence, and many more such petitions. Therefore, the bench is answering questions about how the Constitution governs the relationship between faith and individual across all religions. To help us think through this, we are joined once again by Dr. Gautam Bhatia. Dr. Bhatia holds a BA LLB degree from National Law School of India University, a BCL and MPhil from the University of Oxford, and an LLM from Yale Law School. His scholarship on religious freedom sits at the very center of the debate that the bench is now adjudicating. Dr. Bhatia, thank you so much for being here.
Thank you.
So let me start from the beginning with some preliminary questions before we enter into law and doctrine. Can you walk our listeners through what exactly is being litigated here? What are these constitutional questions that the bench is now adjudicating? Why the five-judge bench decided to make this reference in the first place?
Yeah, so as you rightly said, back in 2018, there was a five-judge bench decision that was delivered on a public interest litigation concerning the denial of entry of women to the Sabrimala temple. It was a 4-1 split. The majority agreed that the exclusion was unconstitutional, although the different judges gave different reasons for holding so. Subsequently, after the judgment, a review petition was filed, which is quite common. Reviews are almost always filed against judgments by the party against whom the judgment goes. Uh, but normally the standard of review for a review, I mean, to succeed is extremely high. There needs to be an error on the face of the record, something so blatant that it's not open to any other reading. A review is not meant to be maintainable if there are two possible interpretations and the judge got it wrong, or maybe the judgment was not as well reasoned, or even if another view was more persuasive. You're meant to overturn a judgment on review only if there is an error on the face of the record. And the other thing is that the review comes before the same bench that decided the original case. Now, here there was a difference in the sense that the Chief Justice, Deepak Mishra, retired after delivering the judgment, and then he was replaced by Chief Justice Gogoi, who then headed the review bench. And along with the review, various writ petitions were filed also on the same question. And in basically a move that really doesn't have any doctrinal or legal basis, the bench clubbed them all together and said that because these questions, these reviews and writ petitions raise these important constitutional questions they will refer it to a larger bench, which again is really irregular. It's really irregular because that's not what a review is for. A review is meant to ask just the question if there was an error on the face of the record or not. But here, the dissenting judge, Justice Malhotra, joined the Chief Justice, who was new, and one Judge, Justice Khanwilkar, who was with the majority in the original judgment, reversed his stand, which again is very odd because this is the judge now saying that I made an error which was so
Error.
blatant that I have to overturn myself without explaining what the error was. So it's all very odd, and it's one of those things which is, I mean, it's one of those cases where clearly, the judges who didn't agree with the outcome of the Sabarimala case, and they
Yeah.
wanted to, change the outcome, and this method was the one that was followed, which is not really, there is a way to overturn a judgment, just that bring another case and then it gets referred to a larger bench. There's a way of doing that, which wasn't followed in this case. Now, the judges then basically, therefore, converted the review to a reference to a larger bench. And when you refer to a larger bench, you don't refer the outcome of a case.
Yeah.
You refer constitutional questions. So in this case, what they've referred to, and like you said, they clubbed a number of cases involving, you know, does a Parsi woman lose her status on marrying outside the religion, and a couple of other cases, basically framing these broad constitutional questions that have to do with the relationship between Article 25 of the
Yeah.
Constitution that broadly guarantees the constitutional freedom of religion, and Article 26, subclause B, that guarantees to religious denominations the freedom to manage their own affairs in matters of religion. So the constitutional questions pertain to the relationship between these two articles, and also about the circumstances under which you can place restrictions upon religious freedom. Is constitutional morality a ground to do so?
Yeah.
And questions of that kind. So these are the questions that the bench is meant to answer in the reference. Again, though, this is just to clarify because there's a big gap these days between what is doctrinally the position and what happens in court. So a reference to a nine-judge bench is not meant to relitigate a settled decision. It's
Yeah.
a reference on a question of law. But if you have been following the hearings, then it is effectively a re-argument of Sabarimala, which is again not meant to be what is happening for a nine-judge bench. For a nine-judge bench, are meant to address the constitutional questions. The nine-judge bench will then answer those questions, and then it will go back to another bench to then decide the review in accordance with the position of law laid down by the nine-judge bench. And this is actually important. This distinction is important because there's a big difference between the position of law as a constitutional matter
Yeah.
and how that law applies to the facts of a particular case. And the latter actually often requires, and specifically in religious freedom cases, requires an assessment of facts.
Yeah.
So it's actually quite irregular that what's meant to be a reference on questions of constitutional law has basically been argued like a re-argument of a fact-specific case.
Yeah.
So that's of course a problem, but yeah, that's where we are right now. That's what's happening before the court and what's happening before the court.
Understood. And I think the context brings out two irregularities in procedure. The first, of course, being the review, the lead up to this reference in the first place, where whether the principles of a review petition were followed or not. And the second irregularity that even I observed while watching the arguments was that even though this was supposed to be a broad question of law hearing, it always ended up with the example of Sabrimala being argued and the questions also flowing from the example of Sabrimala in the first place.
Yeah, and I think just to add a brief point, I think you have to, and I think since it's a constitutional law podcast, I think it's important to flag that unfortunately this has become the default in the Supreme Court, where questions of procedure and what is meant to be argued in what forum have completely disappeared. So, for example, in the presidential reference case or on governor's powers,
Yeah.
again, I mean, the reference is an opinion on a question of law, but it was argued entirely as a re-argument of the governor's case. So
Correct.
basically, what's happening right now is that if the Supreme Court, if a bench of the court delivers, an opinion that other judges don't like, and if the Chief Justice of the court, also doesn't like that judgment, then they will just invent some new way of overturning that. Uh, and of course, the Chief Justice controls the bench. controls the procedure, controls the court. So I think what we're seeing, and this is not just Sabarimala, it's not just governor's case, it's
Yeah.
multiple chief justices over like last 5 or 6 years. It's basically become that they basically look upon their role now as correcting like errors of the court,
Yeah.
which is very dangerous, and it's very bad for any kind of institutional consistency in the Supreme Court.
Yeah.
But this is now normal. This is not an exception. And what we are seeing in Sabarimala is just something that I think now the previous 4 or 5 chiefs have done in their own different ways
Yeah.
whenever they want to. So this is where we are right now.
Yeah. I mean, finality of Supreme Court judgments might be a myth.
It's no longer a thing. Like it's no longer a thing. It's finality of the chief justice's view. That's what the court is right now.
Yeah. All right. So coming back to Sabarimala, the Solicitor General argued that Article 26, is not subordinate to Article 25 2b, that the denominational rights cannot be defeated by an enabling clause of social reform. There are other people who have argued the opposite, that Article 25 and 26 form a connected scheme and must be read together. What do you think, in your view, is the correct relationship between Article 25 and 26? Are they co equal, or does one govern the other?
So the text doesn't answer this question because the text creates these two articles, and there is a religious freedom clause, and within 25 it's clearly stated that one of the grounds for restricting on the freedom of religion is a law that brings in social reform. And of course, if you look at the debates in the Constituent Assembly, if you look at history, the idea there is practices like sati, practices, untouchability, lack of access to temples of castes, all of that.
Yeah.
That was the governing motivation behind that social reform clause. And of course, the idea was that Parliament would be the body that would bring about that reform through laws. And that's been affirmed by cases like Venkat Ramana Devaru, which is, of course, an important precedent in this context. Uh,
Yeah.
Now, to me at least, there are two things. I think one thing is that it does not make sense to have a position that the 26B is superior to 25(1), because that is the logical consequence, right? So you're saying that the religious denomination has a superior right to the freedom of conscience if the latter, and religion on the individual basis, if the latter is made subject to social reform laws, but the former is not. It also makes no sense because many of the most pernicious practices that 25(2)b seeks to deal with
Yeah.
are institutional practices. So untouchability is an institutional practice; it's not an individual practice in that sense. So once again, exempting 26 clause B from social reform legislation, to me, is basically like it's unsupported by what these two articles are meant to be trying to do, which is which you get from history.
Yeah.
The second thing, of course, I think is that a more important question also is, and I think like this actually, if you answer this question correctly, then all of this becomes quite irrelevant. Which
Yeah.
is to say that how do you define religion or matters of religion? And that's been a very old question. And the reason why it becomes relevant in the Indian context is the realization that Ambedkar had in the assembly, which he articulates, which is that unlike say Protestant Christianity or modern day Christianity, where there is this clear separation between what happens in the church and what happens in civil life.
Yeah.
There is not that separation in India, where religion always has and still does occupy a pretty significant role in civic and public life. And so the point Ambedkar made is that the conceptions of religion in this country are so broad that if you were to allow self-definition in terms of what constitutes what is religion, you will basically place inheritance laws like marriage laws, property laws, all of that outside the pale of legislation. That obviously
Correct.
cannot be the position. And so he said that we must restrict the reach of these clauses to that which is essentially religious and not essentially civil in nature. And I
Yeah.
think that if you actually were to apply that test in a proper manner, you wouldn't really even be facing the question of 25(1), 26(b), 25(2)(b), because most things that are purely within religion, properly understood, then wouldn't really have an impact on social life. So if you restrict the scope of religion, then automatically you have that problem goes away. Now, of course, we still have controversies, we still have gray lines, gray areas, but I think that's a more promising line to take than to try and like work out 25(1), 2b, 26b, what is superior, what is not.
Yeah.
I think drawing a clear line between the secular domain and the religious domain is a more promising way to go, but I don't see it happening via the court at least.
Understood. All right. There's another aspect of the relationship between 25 and 26 that I wanted to discuss, which is the enforceability and the vertical horizontal relationship. So
Yeah,
25 says that all persons are equally entitled.
yeah,
26 says every religious denomination.
yeah.
Now, a right against the state is a vertical right, a right against a private religious body would be horizontal. Now, how does this vertical or horizontal idea shape these two rights? Is there is there something that the court can or cannot do based on whether it reads something as vertical or horizontal?
Yeah, I mean, so look, Article 25(1) is your classic right where you are preventing the state from infringing on my religious freedom, right?
Yeah.
So, which is, the right that's there in all constitutions, in all modern constitutions. So the state cannot come in and tell me, oh, you can't worship this God, you can't worship in this way, or the religion is wrong, or, and of course, 27, so we will tax you because you are in the wrong religion. So it's
Hmm.
meant to erect this like wall between your religious freedom and the state.
Yeah.
But what often happens, in any religion,
Hmm.
is that there can be a clash between the adherents of the faith in how
Hmm.
to interpret the religion and what it requires, right?
Yeah.
So I mean that's how Christianity split into Catholicism and Protestantism and all of that. So there's always internal religious dissent,
Yeah.
and so then the question is that if the denomination, or so to say the denominations, institutional structures
Hmm.
interpret religion in one way, uh, and I, as an individual, person of the faith, interpret it in a different way,
Yeah.
then there could be a possibility where my 25(1) right will clash with the 26b right of the denomination. Right? So,
Correct.
to give you an example from a very famous case, Dawoodi Bohra case from 1962,
Yeah.
this was about excommunication, right? So, the state of Bombay back then passes a law to prohibit excommunications, and the entire idea was that we will protect the individual dissident within the faith from
Yeah.
being forced to pay the price for dissenting views
Different.
within the faith. And Supreme Court strikes it down as basically being, an unconstitutional restriction on freedom of religion. So that's
Yeah.
an example of how these rights could potentially clash.
Yeah.
Now, what is the answer there? Again, I think there are different views you can take. My personal view is that basically when the difference between the individual's like expression of faith and the denominations interpretation of religious obligations results in what is in effect a loss of civil rights in some way. At that point the court can, or the legislature can, step in and regulate that and protect the dissident. So excommunication is a classic example where, I mean, the excommunication from the faith, which is the example cited in the dissenting judgment in Dawoodi Bohra, which upheld this anti-excommunication law, is basically you lose access to communal burial places, communal dining spaces, things like that. So basically, it's you basically are excluded from a community entirely, which is in many ways a loss of civil rights. So I think that at that point, the law can step in and say, okay, when a religious dissenter is being penalized uh, in ways that go simply beyond the faith itself and
Yeah.
enter the secular civil domain, that's when we intervene. And of course, you're going to have gray areas on when that is, right? And there'll
Yeah.
be a lot of controversy over when that sort of switch takes place. So, for example, in the US, there was this controversy over can women priests be ordained, and the
Hmm.
Supreme Court said that, well, this is purely a religious, thing. So this is not a question of equality being violated in the general public sphere. It is purely an unequal treatment within the religious domain with no real impact on anything beyond that. Now, that's easy to say in the US, where you have that clear separation between religion and the public sphere. It's
Hmm.
much harder in India, where you don't. So that becomes then a problem. But that is sort of, I think that is the correct approach.
Right. So the focus or the test then should be whether the practice leads to a loss of civil rights or the anti-exclusion principle, as you've mentioned. Um, Staying on the textual point of Articles 25 and 26,
Yeah.
25 2b says that the the social reform, or it talks about throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus. Now, there have been arguments on how we should interpret classes and sections of Hindus. One argument goes that you read it in the historical context where it was only supposed to be a caste based exclusion, but there's a more progressive view which says that even exclusion based on gender discrimination should be included. So, how would you read these two interpretations?
Yeah, I mean, so obviously the intention behind the provision is predominantly to bring an end to the practice of caste-based discrimination and access to temples. There's no doubt about that. But in constitutional theory, there's a difference between application intent and like the meaning of the word. So, for example, this very common example is that when the Americans drafted the 14th Amendment, Equal Protection of Laws,
Yeah.
many of them were full-blown segregationists. They never intended that this provision would apply to or would require desegregation between black and white people, except that the word they used was equality or equal protection of laws. So the application intent of a drafter is not exhausted by sorry the scope of the scope of the application of a constitutional provision is not exhausted by the application intent of its drafters. And so, if there is a coherent and principally sound, justification for interpreting a provision in a broader sense, then there is no reason why it can't be.
Okay.
And in this case, obviously, I would say that, and again, independent of Sabarimala, I would
Hmm.
say that if the reasons that for which you exclude someone on the grounds of caste are
Yeah.
analogous to why you would exclude someone on the basis of gender or any other such marker, then that provision should apply. Now, the crucial question is that, say, in a case like Sabrimala, does the analogy hold or not? Right? Like, is the reason for excluding women something that is analogous to why you would exclude certain castes, which is a factual question, right? And that's not something that the present reference quote is equipped to answer. Also, importantly, it wasn't something that even the original bench was equipped to answer, because that's something you do in a suit, in a civil
Yeah.
suit,
No
right?
civil.
Not in a PIL, and we can talk about that in a little while. There's a question I know you have for me on that. But I think that ultimately, to answer the constitutional question,
Hmm.
I see no reason why the interpretation of sections or classes can extend beyond caste, where the reasons underlying exclusion are analogous to why you excluded certain castes from temples, which of course is like hierarchies, purity, pollution, things like that.
Yeah. Understood. I think it just goes back to the limits of the original intent. How much does originalism play a role in constitutional interpretation, where you can also use it in the present context and mold it in the present context. Perfect. So next, let's move on to another contentious issue of denomination. The Sabarimala majority held that the Ayappa devotees did not constitute a religious denomination. And of course, this was the pillar of their decision. The moment you say that some group of people is not a denomination, they almost immediately lose their rights under 26B.
Yeah.
So, how do you think denomination should be understood? Is it something that can be, if it's broadly understood, does that mean that anyone can come up to the court and be like, we are a denomination? Where do you draw a test for it?
Well, I mean, you have to obviously, you have to show certain, a certain consistency of practice, belief, and faith, and rituals, and certain kind of say, internal governance mechanism, things like that,
Yeah.
to show that you are a denomination within religion. Now, again, the problem is that this is a matter of trial, right? So,
Mm.
and in the British times, these questions would always be decided in a trial, in a suit.
Yeah.
So again, a public interest litigation is not where you agitate questions of, is this a denomination or not? But yeah, broadly, to establish that, you have to show that there is a commonality of like doctrine, ritual, practice, sort of internal institutional governance
Yeah.
that sets apart the denomination from the broader faith that it's part of.
Got it. But one of the arguments was that since, Sabarimala can be visited by people from any faith,
Yeah,
it loses its status as denomination. But to me, if openness of access is a determinant factor of denominational character, then you have examples like the Haji Ali Dargah in Mumbai, the Shirdi Sai Baba temple in Maharashtra, where people from across faith go and visit.
yeah.
So does openness become that big of a factor while determining the denominational status? Because then you're effectively saying that on the basis of exclusion, you will prove whether or not you are denominational, whether or not you have denominational rights or not.
No, I mean, so a denomination can choose to have a public temple. Like that's totally fine. So it's not dispositive at all. It
Okay.
gets dispositive in cases where part of the like denominations like core beliefs themselves include exclusivity, right? So
Okay.
I can't remember now. I think it was Venkatraman Devaru. I'm not sure now because I'm a little hazy on this. But there was one case where actually it mattered because the denominational nature itself was grounded on having like a particular temple which only you could access, and that was the claim made by the denomination itself to show it was a denomination, and then it
Yeah.
was found on evidence that it wasn't actually the case.
Okay.
So in certain cases where the denomination itself is claiming that part of why we are a denomination separate from the rest within the faith is because we have our own exclusive temple, and then you
Yeah.
show practice that is showing that obviously wasn't the case historically, then it makes a difference, obviously. But the mere fact of having a public temple does not deprive, in my view, does not deprive a group of denominational status.
So you would agree that the understanding in the original Sabrimala judgment about denominational was restrictive in its sense and
Yeah,
should be
yeah.
brought up. Okay.
But like I said, I
Understood.
don't think that for me, like on my preferred reading of the Constitution,
Yeah.
or that it gives you threshold protection, obviously. But the point at which your exercise of denominational freedoms deprives somebody of civil rights, that's when it can still be overridden.
Correct, correct. And I think this point would also be more important once we talk about the scope and extent of judicial review.
Yeah,
And in these arguments, throughout the judgment, throughout the arguments, no doctrine has come under like such sustained attack than the essential religious practice test. So, could you briefly explain what this test is
yeah.
and how it came into existence historically?
Yeah, so the Essential Religious Practices Test, the ERP, basically says that in order for practice to be given protection under the Constitution, it must be an essential religious practice. So something that is essential to the faith, something that is without which, like it could not, the faith wouldn't be the faith.
Yeah,
And of late, it has effectively meant something which is mandatory or obligatory in the faiths, like the hijab case, things like that.
yeah,
The actual adoption of the ERP test basically rests upon a misreading of the Ambedkar line I mentioned a little earlier, where where he said that we must restrict the scope of these clauses to that which is essentially religious. And his whole idea was, how do you draw the line between the religious and the secular in a constitutional democracy where religion plays such an expansive role in public life?
Got it.
In the first two cases after independence, the Shirur Mat case and Ratilal, if I remember correctly, that was broadly the way they understood the phrase. But subsequently, and following cases like the first cow slaughter case, Mirzapur Moti, the court performs this linguistic sleight of hand where it shifts from essentially religious, which is the religion secular distinction,
Yeah.
to essential religious, which is what is essential to the faith. Now, this leads to two things. One is that the court uses this test to get rid of what it claims are superstitions or practices it doesn't like. So, under the chief justiceship of Justice Gajendra Gadkar, over like many years in the 60s, the court basically reinterprets religion in a more broadly progressive direction by eliminating what it calls superstitions, by saying these are not really essential to the religion. And then also, of course, it makes the judiciary the arbiter of what constitutes that which is essential to the faith or not. And
Yeah.
thus, you have, I think, what is obviously an absurd situation where, for example, in the Anand Margi case, the dance in Calcutta,
Yeah.
the Supreme Court first says that this is not essential practice, this dance. Then the founder of this sect writes a book where he says this is essential, and the court, it goes back to court. The court says no, we know better than the founder. It's not essential, right? So you have this sort of completely absurd situation going on.
Yeah.
And so yeah, basically the origins of the test rest, I think, in a linguistic misreading, and it's, I think, clearly, doctrinally, philosophically unsustainable, because it involves the court in answering questions that a, it is not equipped to answer,
Yeah.
and B, and I think this is where, this is my objection to it. I think it's different from many of the lawyers. It basically strengthens the hold of orthodoxy, right? Because the people the court will have access to, or the loudest voices, are the orthodox, right, within any religion. So again, you have the situation where the dissenter will hardly be able to like get their voice heard. And I think also you had this bizarre thing where in the hijab case in Karnataka, the whole thing became about, is the hijab mandatory or not? And ultimately, the decision was based on the court finding that according to the Quran and the Hadith, the hijab is not mandatory and therefore
Yeah.
not essential. And to me, this is an inversion of what should be the case, right? Because it should be a matter of individual conscience.
Yeah.
What the right guarantees is the right to religious freedom, not to religious obligation, right? So it's inverting the whole meaning of the test, and that's inevitable. The moment you say there is something essential to a religion, you get into questions of, is it obligatory? Because there's a very close link between essential, something so important, the religion will cease to exist, and it being mandatory, right? So you can see how the link goes. So I think that therefore, for me, that's the bigger reason why the test should be abandoned. And yeah, I'm aware that I think some counsel in the case did actually make this point about the linguistic misreading, but
Yes.
they didn't cite, I think, the source, which, that's fine. It's previously also a very famous senior counsel plagiarized this argument of mine in a Times of India piece and didn't cite me. So I think this has been like a common thing that's been going on for a while with this argument. Because I think I first made this argument about like this linguistic misreading back
Yes.
in 2015 or something, regarding Santara, the Rajasthan High Court's practice of when the Rajasthan I think High Court had temporarily banned
Ban Santana.
Santara, and I think after that I've seen it basically being copied by various lawyers without attribution, but that's okay. That's how it goes in our practice.
Yeah, I think the whole interpretation of how Durga committee misread Shirur Math. I mean,
Yeah,
we read it from your article, but then eventually
yeah.
it's now become
It's now,
famous.
it's now folk wisdom in the court. Yeah,
Yeah.
yeah,
But I want to go back to the example that you mentioned about the hijab case.
Yeah.
Where the state says that this is college dress code, that's why it's a secular practice of a secular institution. The woman says that no, this is my act of faith. Now, even if we ditch the ERP test of saying, okay, you look at religious versus essentially religious, even if the court is supposed to look at only religion versus secular, the court inevitably has to ask, is this religious dimension of hijab, for this example, substantial enough or integral enough so that it overrides the secular regulation? And I think that even if the moment you even look at religion versus secular, you always would end up with a ERP sort of test. So would you say that the binary should now shift from religion to secular, or some other method that you've mentioned?
No, so for me, the correct test has been evolved, across the world. It's sort of it's a test used in multiple countries, which is
Yeah.
the genuineness of belief, which is a matter of evidence which you show over time, right? So if I
Yeah.
claim that my religion, or let's say my interpretation of my religion,
Hmm.
like this is what I want to do as an expression of religious faith. I The court looks at, is your past behavior consistent with that, right? Or did this just happen overnight? Of course, there are problems there, but basically it is you're testing not if, like, the religion as interpreted by the orthodoxy mandates something, but
Hmm.
am I being consistent in claiming this to be, my religion's, requirement,
Yes.
which is basically, yeah, it's called the test of genuinely and sincerely held belief. So I think
Hmm.
that's the correct test that allows play in the joints for the individual to again shape and reinterpret the religion as they want. Now,
Yeah.
as to your question, like, how do you distinguish between the religious and the secular?
Yeah.
That's exactly the point that's made by Chief Justice Sinha, in his dissenting opinion in Dawadi Bora, which is
Hmm.
that the point at which the exercise of my religion, or my claimed exercise, whether denominationally or individually,
Yeah.
infringes on somebody else's civil rights, that's at the point at which you say this has now come to secular domain, right? So this has now come to the domain of the secular, and that's where the freedom stops. And of course, then also you have the regulatory power of the state, which comes across with 25(2)(b) and 25(1), subject to all of that, right? So you
Yeah.
have, like, you still have scope for both the state's regulatory power to operate,
Hmm.
and the protection of other people's civil rights,
Hmm.
if you abandon the ERP test and adopt the test of genuinely held belief.
Yeah, got it. So I think the focus should be on genuinely held belief, and then
Yeah,
the line that you would draw would be through whether or not the right infringes someone
yeah,
else's civil rights
yeah,
or leads
yeah,
to an exclusion in the
yeah.
beginning. All right.
And of course, the state can justify its regulatory moves through 25(2)(b) and 25(1), the
Correct.
preliminary clause. Right? Yeah, yeah.
So the social reform power still remains with the state
Yeah,
to
yeah. I mean,
enforce
except
it.
that it must demonstrate how it's social reform and all of that. I mean, it is obviously the state can't just state that no, this is social reform. That can be a matter of argument.
Correct. Understood. All right. So now moving on from denominational rights, ERP, into something more abstract, I would say, is the issue of constitutional morality.
Yeah,
Now, the Sabarimala majority relied on it heavily. Chief Justice Chandrachud's opinion used it to argue that societal or mob morality cannot override constitutional values. How do you read this entire debate about constitutional morality? Since it is deployed from Navtesh Singh Johar, is it a legitimate constitutional tool, or is it something that the court has just now created?
constitutional morality is just constitutional principles. Constitutional morality obviously is not a ground to strike down legislation. I
Yeah.
can't invoke constitutional morality to say that, like, I have to peg my challenge to a law on a provision in the constitution.
Hmm.
Let me give you an example, right? So reservations, right?
Yeah.
I can't say that reservation is like unconstitutional or constitutional by invoking constitutional morality. right?
Hmm.
But as the Supreme Court held in N.M. Thomas, the vision of equality that our Constitution subscribes to is substantive and not formal. And therefore, when you interpret 16 Clause 4 as a facet of 16 Clause 1 and not as
Yes.
an exception to it, you are deploying constitutional morality, right? Because you are saying, okay, the moral vision of a society of substantive equals
Yeah.
is the vision our constitution subscribes to, and not the moral vision of a constitution of just formal equals, right?
Correct.
So that's what you're using it for. You're using the phrase to understand what moral vision is contained in the constitution to interpret its own provisions, right?
Yeah.
And I don't say you can. I mean, if you don't like the phrase constitutional morality, you need not use it. But there has to be some moral standard to to determine substantive equality or formal equality. Free speech, is the justification democratic? Is it autonomy based? So whenever you interpret a constitutional provision, you are applying a certain moral vision to interpreting it,
Yeah.
and you have to obviously anchor that within the broader constitutional text, design, and structure. And that's just what the phrase means. It doesn't mean anything beyond that.
Yeah. But the way it's being used is to also justify striking down legislations and
Yeah, I mean, obviously, it can't be a self-standing ground. That's not possible. So obviously not.
understood. All right. Now, from constitutional morality, there's also one big question that has come up by the bench largely. Justice Nagranatha has repeatedly pressed on the question of who exactly brought this case, referring to the Sabarimala question, the whole question of locus standi.
Yeah,
And for example, if we look at the religion of Jainism,
yeah,
they have this practice that you mentioned of Santara, which is
yeah,
voluntary fasting onto death.
yeah.
Now, if I find that practice troubling, can I just walk into a
Which
court and
someone did,
file?
and they went to court. So someone
Yeah.
did find that troubling. Yeah, yeah,
And I mean, even though I might not be a Jain, I have no
yeah,
connection to the community, I'm not affected by the practice in any way except saying
yeah,
that, oh, I find this troubling.
yeah.
Now, is what should be the threshold for entertaining PILs in religious matters? Should there be a threshold to begin with?
Yeah, so I think this is a very important question. It's an important question because I think here is one of those places where the question of standing is inextricably intertwined with the substantive question of constitutional law. And which is also why back in 2018 I agreed with Justice Malhotra's dissent on this point. Because so basically, if the argument is that a certain religious practice or denomination is a violation of like my civil rights,
Yeah.
to X or Y, then that is obviously itself a contested claim, because when something goes from the religious domain to that domain is going to be disputed. So now, of course, in some cases it's obvious, like sati, obviously you're burning someone, right? So like,
Yeah.
there's no question there. But something like excommunication, right, is more complex, because I may be totally, I may be like, fine, I will find my community elsewhere, right?
Yeah.
I don't mind being excommunicated, like that's okay. Or it may have like a genuinely bad impact on me as like an equal member of society. I can't access those kinds of community spaces. So basically, these in I think in many cases, uh, the question of if a certain ostensibly discriminatory
Yeah.
religious practice effectively goes beyond the religious domain and enters the public sphere is something that can only be determined by those who are affected by it, right?
Yeah.
Because if they don't think it affects their civil rights, that itself is a good reason to hold that it does not. So for example, let's take Sabrimala, right? So
Yeah.
so in Sabrimala, now if the argument, of course, is that the basically, I mean, to simplify, the argument is that the deity is meant to be celibate, right?
Yeah.
And therefore, menstruating age women cannot go before the deity, right? Now, you might, on the one hand, argue that this is a menstruation-based exclusion that is grounded in certain notions of purity and pollution that are very similar to caste-based exclusions, and therefore this is very clearly not just religious, but it's a broader issue of social discrimination, right?
Hmm.
But if the argument is that this has nothing to do with the uncleanliness or cleanliness of menstruation, but
Yeah.
actually is just a belief that the deity wishes to be celibate,
Yeah.
and therefore it's not actually it's not actually sending out a signal of
Hmm.
discrimination. That question really depends upon what are the beliefs of those who are affected by that, right? So
Yeah.
so if not a single woman worshipper of in Sabarimala temple
Hmm.
actually feels that they are being discriminated against by this, then
Yeah.
I think that there's no real ground for saying that.
Correct.
Uh, and so now there are two exceptions, right? Like one is something like sati, like I said, which is basically the harm is so obvious that it's no longer subjective, right? So
Yeah.
there are those kinds of cases. The other is that if there is a situation where you have credible proof that there is a minority within a religion that is so oppressed that they don't dare to speak out, right? Then that's the whole idea.
Yeah.
The PIL is meant to be when you come to court on behalf of someone who cannot come to court, right? Because either they don't have access to court or they fear reprisals, right? And of course, perhaps at some point, and even now in some cases, there could be situations where it is impractical or unfeasible
Hmm.
for the actually affected people to come to court, either
Yeah.
because they can't access the court or because they have a genuine fear that they will, that there will be reprisals against them for doing that.
Hmm.
Is that a case in Sabarimala? I don't think so. But also, then, if it is a case, then it should be established in some
Yeah.
way, and there should be a question the court asks, right? Like, so why is no woman worshipper here before us?
Hmm.
It's a question that should be asked, and again, perhaps the answer will be one that will establish standing, right? Like maybe it will,
Yeah.
but I think you have to ask the question because I think this is a case where the two questions are intertwined. The
Hmm.
question of standing is intertwined with the question of, is this internally religious practice
Hmm.
discriminatory going beyond religion, right?
Yeah.
In a way that you don't ask in like other discrimination cases, which are not to do with like the subjective like perception of the people who are actually affected by it. So I
Correct.
think that yeah, like I think if your test actually is that the denominational freedom is subject to what I call the anti-exclusion principle, which is
Yeah.
what I described a little while ago. Then you have to ask the people who are affected that do you feel excluded by it, right? And
Correct.
then if they say yes, then the next question rises: is this like objectively true or not?
Hmm.
But I think you can't go forward without asking the question first.
Correct. So you just limit the standing to the people who are excluded, using the anti-exclusion principle to solve essentially two problems at once. And I mean, for questions like sati, the constitution itself would allow you because it's subject to public order, health,
Yeah,
and morality.
yeah,
So those kind of extreme cases, anyways, would be covered quite easily. And of course, the whole question about filing PIL and what the principle should be, the court
yeah.
has sort of established a strict regulation on it, and they've like come out and said that this is not publicity interest regulation, interest
But look,
regulation.
these are
Yeah,
all very rhetorical phrases, right? Like it,
yeah,
you want a test that doesn't allow judges to decide on a case by case basis when to
mm,
admit and not to admit, right? So
yeah,
you have to have like an actual genuine test with bite,
mm,
where it's not discretionary.
yeah,
Publicity interest is so discretionary, right? Like one judge may think publicity, one may think this is fine. So you have to have like a proper enforceable test that is not completely subordinate to the judge's perception of litigants.
mm. Do you have any idea of what that could be, or is
No,
it something?
like I said, right? Like the in these kinds of cases
Yeah,
where the fundamental claim is that somebody internal to a religion or denomination
mm,
is facing discrimination,
yeah,
then they have to be before the court claiming why they are facing discrimination.
yeah.
Failing which there must be a very high threshold of showing that they basically there's no way they can come to court, and not that they're not choosing to come to court.
Understood. Understood. All right. So one last question for you, Dr. Bhatia, which is that what do you anticipate this? reference order or this judgment to look like? What do you think the nine judges would
Yeah.
possibly hold? What the implications could be?
Well, I think so. I think look, it really depends on the level of abstraction to which they peg their judgment, right? So I mean, I think that it's very clear that the manner in which this case, and I don't mean the present bench, but the manner in which this case was referred makes it clear that there is a sentiment in the court that the original Sabarimala judgment was wrongly decided and should be overturned. So I think if the judges decide to basically uh, decide this case as a re-argument of Sabarimala, then obviously the Sabarimala will be overturned. If, on the other hand, they actually engage at the level of abstraction that the reference to nine judges demands,
Yeah.
then I don't like. I think there's no way of predicting what will be the case, because we are actually in quite new territory, right? Because now ERP has been questioned, and the kinds of questions that are placed before the court have not really been properly engaged with before, because since Shirur Mat, even though there was an internal shift in ERP, since Shirur Mat, the doctrine has been consistent, which is
Yeah.
now what, 60 years, right?
Yeah.
So I think it's impossible to predict like what doctrinal shifts there will be, because we have no indication of any sort of like base from which to like start reasoning that this could be the base. So I think like if they do decide to actually adjudicate the case, if they answer the questions at the same level of abstraction that the questions are framed, then I think there is no way of predicting.
Correct.
But if they do it in a more concrete way, then I think the obvious outcome is that the outcome in Sabrimala will be overturned.
Understood. All right. So thank you so much for being here. We've talked about, from starting about the irregularities which led to this reference, the relationship between Articles 25 and 26, how denominational rights should be understood, what the anti exclusion principle and the future of ERP looks like, and the questions of constitutional morality and standing. Thank you so much for being here, for giving us your thoughts, and it was a pleasure talking to you.
Thank you so much.